Hi, Attorney Wendy Guthro. This is some basic information when someone is just starting to do their estate plan, doesn't really understand a lot of the concepts or terms. So first, you would normally have a will, and that's where you designate who is going to be in charge of your assets, the property you own when you die, and who is going to distribute it to what we refer to as the beneficiaries. Those are simply the people that are going to get your money, property, belongings when you're gone. The other thing is a trust, and a trust is simply a container to hold things, and that trust, if it's a revocable trust, is something that you could put your assets in so that you don't have to use a will. What's the benefit of that? Well, a will, you have to involve the court system to distribute the assets to the people you want who to receive your assets. Where a trust, you don't have to involve the court. So it's simple, faster, private, lots of good reasons to do a trust. Then you have a power of attorney, also referred to as a durable power of attorney. That is a written document where you are going to select somebody that you trust emphatically to do the right thing, to manage your money when you can't do it yourself. That person's called the attorney in fact, but that's not important to remember right now. Just that you want to have a power of attorney in place for someone to manage your financial affairs in case you are alive but incapacitated. You can also have it be for when you're alive and just for mere convenience. You want somebody else to go to the bank for you, or talk to your retirement company, or talk to your brokerage house. So that's what a power of attorney does. It's a powerful document. It's a great document to have. And most clients use that during their lifetime in good and bad times. And it's normally used prior to your passing because power of attorney can no longer be used once you pass away. Now, the remaining 3 documents I recommend my clients have, they're 3 healthcare documents. It's a healthcare proxy, and that's when you're going to choose someone, your healthcare agent or proxy, to make medical decisions for you, but only when you can't make medical decisions for yourself. So if you can tell the medical community what you want done, you're in charge. You don't need your healthcare proxy. But when you can't do that, that's when you already want to have your healthcare proxy in place. Second of the healthcare documents is your HIPAA. Your HIPAA is a document where you list either individual people or a group of people, such as my spouse, my children, my siblings, or just one sibling and one child, whatever you want. You list names or groups of people that you want to have access to your protected healthcare information. What is that? That's all the secret stuff that's in your medical records, as well as the mundane stuff, such as who can talk to your insurance company and settle a bill for you. The most common use I see for a HIPAA is that when somebody calls the hospital and wants to know how you're doing, that if someone's on your HIPAA form, they can speak to that person and let them know. So even though that's the most common use, you have to also be aware that there are other functions that can be attained with the use of a healthcare proxy. And the last document is your advance directive, also called a living will. And why is it called a living will or advance directive? Because in advance of you passing away, you're going to give advance direction to your medical team of whether or not you want to be kept alive on life support, but only if death is imminent, no quality of life, and that you are likely not going to survive unless there are major medical interventions taken on your behalf. On that living will advance directive, you can say that you do want life extending measures to be taken. Or you can say, nope, no interest. If the doctors are saying to my family that there is really no quality of life for me, I am telling my family and the medical community with this written document what my directives are, what my intentions are, whether or not you want to be kept alive on life support. So that's the summary of basic estate planning in plain English to try to have you understand what you're going to be doing when you ask an attorney to assist you with creating estate planning documents. Thank you.
If you would like help or have questions about this information, please give us a call at 781-229-0555 or visit our website at guthrolaw.com. We look forward to hearing from you.